Well, good morning, all. Uh, well, good morning, all, and welcome back to the Rhine Report. Much maligned, misunderstood, ignored, marginalized. However, here for all of you who are open to it, to not merely endure, but to profit from. Finally, as of yesterday, a judge has stepped forward to make a declaration about the Alien Enemies Act of 1798 being used to arrest, detain, deport, and imprison Venezuelan and others. And it was about bloody time. Because, as reported by Alex Woodward in the British independent newspapers, which I'm going to report on, I'll begin by reading from his article. It's titled Trump Appointed Judge Blocks Unlawful Alien Enemies Act Deportations and Sets Up a Major Legal Battle. Trump appointed Texas District Judge Fernando Rodriguez delivers a sharp rebuke of government's legal arguments behind these mass removals. The Trump administration's use of the Alien Enemies Act to summarily deport Venezuelan immigrants accused of being gang members, quote unquote, exceeds the scope of the law and runs, quote unquote, contrary to the plain, ordinary meaning of the wartime statute, which we'll get into and I'll come back to in a minute. Texas District Judge Fernando Rodriguez, who was appointed by Trump himself, ruled on Thursday that the administration cannot rely on the 18th century law to detain and deport alleged Tren de Aragua members, which is unlawful. The government does, quote unquote, not possess the lawful authority under the Alien Enemies Act based on Donald Trump's proclamation invoking the law for the fourth time in U.S. history to detain Venezuelan aliens, transfer them within the United States, or remove them from the country, according to the judge's 36-page ruling. Now, I might add here that it really was the duty of the Supreme Court of the United States in making its 9-0 ruling, backing up Judge Boasberg and Judge Zenas and their rulings to facilitate, not effectuate, the return of these Venezuelans so that they could enjoy due process owed them as it would any other person or citizen within the United States of America's territory. It's clear that Justice Roberts threw in a monkey wrench when he substituted the word facilitate, excluding the word effectuate, to the ruling. It just simply made it hard for the lower courts to deal with the matter. That was problem number one. Problem number two with that ruling was that it permitted the Trump administration to consider continuing all of its prosecutions in the interim while this matter was being litigated in the lower courts. That's a huge mistake. The Supreme Court had the opportunity to make a clear declaration that the Alien Enemies Act of 1798 was an inappropriate vehicle to use prosecuting these Venezuelans. The judge's ruling applies to all targeted immigrants held in his district. The historical record renders clear that the president's invocation of the Alien Enemies Act through the proclamation exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms, he wrote. Now, I could go into the rest of this article, but I want to stop here, pause, and get down to the plain text, if I can find it, of the meaning. In reviewing, making a legal analysis of the act, which has only been used 3 times, I believe, the War of 1812, the First World War, and in the Second World War, we must look to the text because it's often quoted by the Supreme Court that when you're reviewing any act of Congress, any statutory law, you look to its plain language first. And here we are. An act respecting alien enemies by the Fifth Congress approved July 6, 1798, Statute 2, Chapter yada yada yada, an act respecting alien enemies. And it reads in Section 1, the key section, be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that whenever there shall be a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion shall be perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President of the United States shall make a public proclamation of the event, all native citizens, denizens, or subjects of the hostile nation or government, being males of the age of 14 years and upwards, shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. So, the statute makes it clear that A, there has to be a declared war by a foreign government or nation, or an invasion or predatory incursion perpetrated against the United States by any foreign nation or government, making it absolutely crystal clear that on its face, the use of this law by the executive branch is thoroughly unconstitutional and has to be brought to a stop. End of story. And these issues of contempt are just muddying the situation, making it impossible for there to be a facilitation or effectuation of the return of these Venezuelans to the United States, releasing them from prison in El Salvador, which can be accomplished by the president in a lickety-split second. So, continuing from the article, uh, which it makes it perfectly clear that Rodriguez's preliminary injunction delivers a significant blow to the Trump administration's attempts to swiftly remove immigrants as part of his aggressive quote unquote mass deportation operation unquote. Any appeal of the decision will head to the conservative Fifth Circuit of Appeals in Louisiana before moving, obviously, to the Supreme Court. The administration has admitted in court filings that many of the people sent to this notorious prison in El Salvador did not have criminal records, and attorneys and family members say their clients and relatives, some of whom were in the country with legal permission and have upcoming court hearings on their asylum claims, have nothing to do with Tren de Aragua. And reminding us in this article, on April 7th, the divided Supreme Court had agreed to lift the court order that temporarily blocked the president's use of the wartime law to swiftly deport people out of the country, as I complained earlier on here in this podcast. They didn't have to do that. They should not have done that. They should have made a declaration that it was completely an unconstitutional use of a law intended only in wartime. But the judges said immigrants marked for removal are entitled to notice and an opportunity to challenge their removal in front of a judge in the district where they are detained. Following that ruling, lawsuits changing and challenging immigrants' deportations under the Alien Enemies Act have been filed now in several states. But this is the first one to declare the unlawful, illegal use of a wartime statute to send people not only out of the country, but into an indefinite imprisonment by contract between the United States executive and a foreign power. This does not impugn the possibility of a dignified, quick response by the U.S. government to ask for the return of one of the prisoners that it sent to El Salvador.